Let's prayers. Almighty God, we humbly beseech thee to look with favor upon this Parliament of the Republic of Ghana. Grant that he may perform his high duty as in thy sight. Give divine guidance to the President of the Republic. Endow members of Parliament and ministers of state with discernment and vision, integrity and courage, that through the labors of government this land and people will be well and truly served, and their good purposes for the common human life be realized in our midst. Amen. O God, grant us the vision of our country, fair as it might be, country of righteousness, where none shall wrong his neighbor, country of plenty, where evil and poverty shall be done away with, country of brotherhood, where all success shall be founded on service, and honor shall be given to the deserving, country of peace, where government shall rest on the will of the people, and the love for the common good. Bless the efforts of those who struggle to make this vision a living reality. Inspire and strengthen our people, that they may give time, thought, and sacrifice to speed the day in beauty of Ghana and Africa. Amen. Honorable members, votes and proceedings. 14 July, page 1. Page 2. Page 3. Page 5. Page 6. 7. Honorable Majority Leader.
Mr. Speaker, yesterday I was here, and even though Parliament did not commence sitting early, I was here early in the morning from 7:30 in the morning, and was here just before we began, and then left for cabinet meeting. So, Mr. Speaker, I've been marked as having been absent of permission. I think the appropriate thing should be done. Thank you.
So the Honorable Majority Leader was absent to permission to attend cabinet. That's exactly what happened. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Honorable Minority Leader.
Mr. Speaker, page 10. Even though when I entered the chamber, I saw another paper then advertising it. Accident Investigation and Prevention Bureau Bill 2020, item 7. From the correspondence from the Office of the President is Aircraft Accident Investigation and Prevention Bureau. But Mr. Speaker, as is first reading, we don't have ownership of it. But official correspondence to me from the Office of the President talks about aircraft accident. When you just say accident, are you talking road accident, domestic accident? It should convey the trust of the approval from the Office of the President, whether cabinet or executive approval. Aircraft. So accordingly, I would expect that it be corrected. Thank you, Mr. Speaker.
Thank you.
Speaker, the Minority Leader is right. The matter is about aircraft accident investigation and prevention. It's not any ordinary accident.
Thank you very much. To be effective accordingly. Page 10, 11, page 12, page 13, 14, page 15, Page 16. Honorable Kujeto Ablakwa.
Most grateful, Right Honourable Speaker. Right Honourable Speaker, I tried to catch your eye from page 13. The figure 56,153,500 euros has not been captured accurately in. So if it can be corrected, the and in between 1 and 100 should be deleted so that the exact figure which is being communicated. And I noticed the same error occurs in the subsequent pages 14 and 15. So if it can be corrected. Thank you, Mr. Speaker.
Thank you very much. Page 16. 17. Page 18. Yes, Honorable Majority Leader.
Mr. Speaker, to complement what the Honorable Okujeto Ablakwa just said, the amount stated in figures, that is the euros, of 56,153,500.00 accurately, then it rather should be 56,153,500 euros. That is the most appropriate way to capture it. The and should be between the 1,000 and 5.
Thank you very much. Page 18. Page 19. Page 20. Yes, Honorable.
Mr. Speaker, page 20, paragraph 37, clause 164. The amended provision was translated into the translation of an instrument into the English language by a certified translator approved by the Director of Lands Registration Division. The entry here does not reflect No, that's it. You were not here, so you don't know what happened. the registration, the amendment that was carried should read translation of the instrument into the English language by a certified later approved by the Director of Land Registration Division. That's what it should read. I will explain to you later. I will explain to you later.
So, Honorable, are you reformulating?
What was approved? That was what was approved. The capturing here is wrong.
Thank you very much. Table office, take notice accordingly then. Page 20. '21. '22. Yes, Honorable.
Mr. Speaker, thank you. Mr. Speaker, in respect of amendment number 49 as listed here, in respect of clause 172. The amendment as approved of the House carried has to be to my credit. What the chairman of the committee moved was in respect as specified in the third schedule, and I improved that proposed amendment to read as specified in Form 22 of the third schedule. So it has to be, the credit has to go to me and not the chairman of the committee. Respectfully submit.
Table office to carry. 22. Yes.
Mr. Speaker,
Honorable Majority Leader.
Mr. Speaker, I agree that the member who wants his name captured should be recognized. But the amendment, because there's an earlier amendment proposed by the chairman, if you join to it, your name should be part of it. We cannot say that the patent rights should belong to you alone. You should join the chairman. That's how you should say it.
22. 23. 24. Honorable members, the votes and proceedings of 14 July as corrected is hereby adopted as true record of the proceedings. At the commencement of public business, item listed for presentation of papers. 4. I, Chairman of the Committee of Finance.
Report of the Finance Committee. The request for waiver of import duty, import NHIL, import get fund levy, import VAT, exempt levy amounting to the Ghana cedi equivalent of 1,208,404 United States dollars on machinery, equipment, and raw materials to be procured by Akum Energy Ghana Limited under the 1 District 1 Factory 1D1F program.
The report is duly entered and is for distribution to honorable members. Aye.
Request for waiver of import duty, import NHIL, import get fund levy, import VAT, AXIM levy amounting to the Ghana cedi equivalent of 814,874 United States dollars on machinery, equipment, and raw materials to be procured by Vesta Oil Mills Limited under 1 District 1 Factory 1D1F program.
The report is duly presented and is for distribution to honorable members. Aye.
Request for waiver of import duty, import NHIL, import get fund levy, import VAT, AXIM levy amounting to cedi equivalent of 44,990 United States dollars on machinery, equipment, and raw materials to be procured by Aja Premium Diaper Care Company Limited under the 1 District 1 Factory 1D1F program.
The report is duly presented and is referred to the Constitutional and Legal Committee for consideration and report. Item listed 5. Presentation and first reading of bill. Honorable Leonard Attorney General.
Mr. Speaker, it will relate to item number 5. Item number 5.
Item.
Seek your indulgence to present the paper on behalf of the Attorney General and Minister for Justice.
Yes, Honorable. Let me proceed.
An act to amend the Criminal Laws Act 1960, Act 29, to categorize the offense of corruption as a felony, to provide a penalty for a person who commits the offense of corruption, and for related matters.
The bill is duly presented and read for the first time and referred to the Constitutional and Legal Committee for and report. The first Deputy Speaker will take the chair. Ayes 36. Revenue Administration Amendment Bill 2020 at the constitution stage. Item list. Revenue Administration Amendment Bill 2020 at the constitution stage. Yes, Honorable, where do we?
You would have to call out clause 1. And then, even though there's no advertised amendment, so yes, well, you have to call the question.
Clause 1.
Section 44 of Act 915 amended.
Yes, no listed amendment. Honorable members, is for your consideration. The question is that clause 1 stands part of the bill, and all those in favor say aye. Those against say no. The ayes have it. Clause 2.
Section 4 of Act 915 amended.
Honorable, there's an amendment.
Mr. Speaker, clause 2, amendment proposed. Paragraph C, subparagraph B. Delete and insert the following. B, trade in services or intangible property. Or C, any tax law. Mr. Speaker, in the Act itself, this will be section 74(5), and we are trying to beat up by bringing in subparagraphs. However, in the bill, there is an error. Trade in services is subparagraph B reads trade services. So we are correcting the error in the bill and also breaking it up into subparagraphs. Straightforward.
Honorable members, for your consideration. I put a question. All those in favor of the amendment say aye. Those against say no. The ayes have it. And the question is, clause 2 as amended stand part of the bill, and all those in favor say aye. Those against say no. The ayes have it. Clause 2 stands part of the bill as amended. Clause 3.
First schedule to Act 915 amended.
Honorable Chairman.
Mr. Speaker, clause 3 amendment proposed. Mr. Speaker, the table under column headed purpose of transaction. The 4th paragraph, line 2, after X, insert duty, so that it will read application for license under Duty Act 2014 Act 878. Mr. Speaker, this is the actual short title to the Excise Duty Act and not the Excise Act. So we are
affecting the correct appropriate.
Honourable members, for your consideration, for the question. All those in favor of the amendment say aye. Those against say no. The ayes have it. And the question is clause 3, as amended, stand part of the bill. And all those in favor say aye. Those against say no. The ayes have it. Clause 4.
Fourth schedule inserted.
Chairman.
Mr. Speaker, clause 4 has about 20 amendments advertised. And so we begin with Roman 3 on page 3. Clause 4, amendment proposed under the schedule. Paragraph 3, opening phrase, delete off. The opening phrase reads, the appeals board shall comprise of. We are deleting off so that it reads, the appeals board shall comprise, then the membership is listed.
Yes, we are moving the technology from there. All those in favor say aye. Those against say no. The ayes have it. Further amendment, IV.
Speaker, Roman 4. Clause 4, amendment proposed under fourth schedule. Paragraph 3, subparagraph 1A, line 2. After S, insert preferably, so that 3.1 subparagraph A will read, a chairperson of not less than 10 years experience in tax practice, preferably a lawyer of not less than 10 years standing at the Ghana Bar or a retired superior court judge. Mr. Speaker, the appeals board, as is being composed, wants to restrict the chairperson position to lawyers, and we think it shouldn't be so. Preferably you have a lawyer, it's good. But if you have a tax practitioner of several years experience, you should be able to also chair such an appeals board. Preferably.
Yes, honorable member for Tamale.
Mr. Speaker, the intention is good, but the purpose of this clause is to ensure that a person with knowledge in law is part of the appeals board. And then it's not only a person with knowledge in law, should be a senior advocate. And that is why they have set 10 years at the bar, or he's a retired superior court judge. So that person, if he's not a lawyer of 10 years and above, should be a person who has been a high court judge or a court of appeals or a Supreme Court judge, because you are establishing an adjudication tribunal. And somebody must know the procedure of law. That's why they put lawyers. So preferably to not be there.
Yes, Chairman, which clause are we dealing with?
4, and that will be on page 8 of the bill. Page 8 of the bill, and the composition of the appeals board.
And what is your proposal?
The amendment is to, in subparagraph 1A, to delete S in line 2 and insert preferably, because as it is now, it restricts the chairperson position to lawyers. And the Speaker, the argument that came up was that if you have a tax now of several years' experience, there's an appeals board that you appeal decisions of the Ghana Revenue Authority or the Commissioner General are appealed to this board. Mr. Speaker, this appeals board, if you are dissatisfied with the decision of the appeals board, you appeal to the court. That would be a high court. Okay? And so, if you have somebody of considerable experience in tax practice, you should be able to chair.
What is tax administration? When you say somebody with considerable experience in tax administration, what is it?
Somebody like Honorable Abeji.
When you say tax administration, it is applying the law relating to the taxes members must pay. And so when there's disagreement as to what is the meaning of this, why do you impose a penalty? Well, you're just in the law. When there's disagreement, I think it is safer to have a lawyer presiding. The tax administrators, or experienced as you call them, will provide the technical expertise. But the procedure to ensure that the fair adjudication clearly requires somebody who can moderate and give either side the opportunity to be heard. Yes.
Mr. Speaker, if that is the argument, it means that anybody who works at the Ghana Revenue Authority must be a lawyer, because it's administration of the law, application of the tax law. But there are people who are not, but they have experience in the tax administration by the application of the laws, the tax. So not necessarily the person should be a lawyer, but the person has experience in the tax administration, the application of the tax laws. That will be sufficient to be able to listen to the appeal, because it's going to be the application of the tax law. And with the experience he has, he'll be able to do that. If this work fails, the person then go to the main, the normal tax court process to seek redress. But I think that the argument that it should be chaired by somebody who is a lawyer, it means that everybody who works at GRA must be a lawyer, and that shouldn't be the case.
Yes, Honorable Member for South Day.
Mr. Speaker, I support the present amendment, save that the use of preferably should be taken out, should be deleted. We should simply read somebody of not less than 10 years standing at the bar. At the bar. We don't have to say preferably. Yes, but it says preferably. Very well.
Yes,
Speaker, what's the function of this appeals board? The appeals board shall hear and determine appeals against decisions of the Commissioner General. The Commissioner General himself is not even a lawyer. His deputies are presently, as composed, his deputies are also not lawyers. They are taking decisions which are being appealed against. Now we are insisting that the appeals board should be chaired by a lawyer. So the Commissioner General himself in future cannot chair such an appeals board, even though he would have been giving decisions, tax decisions over the duration of his tenure. So, Mr. Speaker, the position of the committee is that we should not restrict this chairperson position to lawyers. And clearly, if I see the way the argument is going in this house, the lawyers in the house want us to restrict this.
And the non-lawyer space within it. Yes, Honorable Minister for the House.
Thank you, Honorable Speaker. It seems to me that some findings have been made, findings of fact, whether the proper principles of law were applied. Immediately it leaves that realm, you come to the area of adjudication. And when it's adjudication, with the greatest of respect, the variables are many. And if you don't have that kind of legal background, even, for example, if whether the proper discretion has been exercised, it's a whole principle of law that you need to look at. So you are not trying to deprive any other profession of bread. But essentially, what we are attempting to do is to elevate that position to an area of education. And who is best suited to look at areas of education? A high court judge, ex-high court or whatever. Those people who have really engaged in the law. And when you say 10 years at the bar, it's like that is where you have some weight. So please, I think this is a fit case to have somebody of strong legal background to adjudicate the matter.
Yes, Honorable Minister for Monetary Evaluation. Welcome back.
I want the chairman to. Thank you, Mr. Speaker. Mr. Speaker, I want my chairman to back down on this one. The committee's reason is not the best. So, Chairman may.
Yes, Chairman.
Mr. Speaker, to the extent that the Minister for Works and Housing maintains that we are not being deprived of bread, then I withdraw the amendment.
What was the item in the, very well, item 4. So item 4, withdrawn. Item V.
Mr. Speaker, Roman 5, 4, amendment proposed under 4th schedule, paragraph 3, subparagraph 1B, in line 2, before chief, delete A, so that it reads the rank of Chief Revenue Officer, not a Chief Revenue Officer. Chief Revenue Officer.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item VI.
Mr. Speaker, Romans 6. 4, amendment proposed under 4th schedule, paragraph 4, subparagraph 3, delete. Subparagraph 3 reads, a member of the appeals board who is absent from consecutive meetings of the appeals board without sufficient cause ceases to be a member of the appeals board. This is not a regular board that will be holding board meetings. Anytime the appeals board is constituted, then they are going to sit on a matter before them. So if a member is not going to be present, and the composition is 3 members at any point in time. So if a member, if the chairperson constitutes an appeals board subcommittee to sit on a matter, and you are not there, there cannot be a meeting. Okay, so this is not, we don't want to create the impression that they are going to board meetings where this appeals board will be sitting and deliberating on matters. Anytime the appeals board is composed, it's a 3-member committee that sits on matters. And so, proposition that you are absent from 3 consecutive meetings of the appeals board, it doesn't arise.
Yes, honorable members for the consideration of it. Yes. Honorable member for
I'm not understanding the chairman at all, because this is not an ad hoc committee or board. This is a board with membership and tenure of 4 years.
4 years.
If the member of this appeals board for 3 consecutive times refuses to attend or doesn't attend, with no sufficient reason, you must give sufficient reason. But if you are saying it's a regular board, why do you give them tenure for 4 years?
Yes.
And then they are to attend as and when an issue comes up, unfortunately, to be absent 3 times. Why? You must give reasons. If the reasons are not good, you see to leave. Remember, this has nothing to do with a formality of a board or whatever. It is a formal board. It is not an ad hoc committee that sits only when there is a matter.
Yes,
Yeah, I'm surprised at this announcement, this amendment. I know the chairman. He's very diligent in the performance of his duties. I know him. But I don't know why he wants to reward the reduction of duty. I don't know why. Because if a person is appointed a member of the appeals board, he must attend meetings of the appeals board. If he fails, refuses, or neglects to attend meetings of the board without sufficient cause, he should still be a member of the board. It means he's not otherwise prepared to serve on the board. So why should we continue to maintain that person for the reduction of duty? The Speaker, diligent members of Parliament like the chairman should not support such amendments.
Yes, Chairman.
Mr. Speaker, I want to abandon this one.
Proposed amendment abandoned. Item VII. Then it stands to reason that VII will also be abandoned because you're deleting the 3 from where the vacancy occurs. Is that right?
Rightly so, Mr. Speaker, because the subparagraph 3 was referenced.
That's right.
So,
item VII abandoned. Item VIII.
Roman 8, VIII. The Speaker, under the fourth schedule, once again, paragraph 5, subparagraph 4. Delete and insert the following. Where the chairperson, but Mr. Speaker, before that, Mr. Speaker, I think we should go back to Roman 7, and the reference in 4 subparagraph 6. Subparagraph 6b, this has not been advertised, where there is a vacancy as a result of a declaration under subparagraph 5. I think it should be subparagraph 4. Subparagraph 4. Where there's a vacancy as a result of a declaration under subparagraph 4. That's where the minister.
I don't think so. Subparagraph 4 flows from subparagraph 3. But
I'm saying the 5 should be 4. Do you understand? Where the minister may, by a letter, address a member, revoke the appointment of that member. So we are saying that where there's a vacancy, A, under subparagraph 2, 3, and then B, as a result of a declaration under subparagraph 4, and not subparagraph 5. Why are you shaking your head like that?
Yeah.
It is not advertised, but in paragraph 4, subparagraph 6b, subparagraph 6b, the reference is as a result of a declaration under subparagraph 4. Do you get it now? All right.
No, the 5 is standing on its own. The 3 and 4 speak to the same issue. but the 5 is where, as of providing reasons which the minister may consider.
The 5 is that the minister shall determine whether the inability may result in the declaration of a vacancy. Yeah. And we are saying that where there is a vacancy, referencing where a minister may by a letter address member revoke the appointment of that member in subparagraph 4. Leader.
Yes, that one is
Paragraph 5 is right. And subparagraph 2 is right. And subparagraph 3 is right. It's just that subparagraph 3 should read subparagraph 4, but the 5 should remain. Why? Subparagraph 4.2 talks about resignation of a member. 3 talks about where a minister has failed, neglected, or refused to attend meetings. And 4 is a standalone provision. The minister can revoke the appointment of a person. It's a standalone. To attend meetings or not, the minister can revoke the appointment. And so that's a standalone. 5 is dealing with. Who says that where a member of this board for sufficient cause unable to act as member, the minister shall determine whether the inability may result in a declaration of vacancy. So where the minister declares a vacancy, and that is where is a vacancy? So where the minister declares a vacancy, there will be a vacancy declared, paragraph 5. You get it?
Yes, but I think the subparagraph 5 should stand. So let's proceed to VIII.
Speaker, Mr. Speaker, before I move the amendment in Roman 8, in Roman 8, the business of the appeals board is spelled out. And the appeals board is duly constituted for its work by members. Now, the amendment we seek to effect here is in subparagraph 4, that where the chairperson is not a member of the panel constituted in subparagraph 3, a member of the appeals board nominated from among their number shall preside. Now we want to say that the chairperson shall designate. That is why initially we said the chairperson should not stricto sensu be a lawyer, because when you constitute an appeals, now there are other members who are going to do the same thing. You understand? So if they are not lawyers, if an appeals board is constituted, 3 members, and that's not presiding, because you can constitute more than one panel at a time for speedy adjudication. So if you go back to restricting the chairperson's position to lawyers, you see the difficulty.
It's different from presiding on a panel. Yes, Tamale.
You are right with the amendment because you want to allocate responsibility. But it is not the case that if a lawyer, the amendment that you are seeking to effect doesn't say that the lawyer is not somebody who has no experience in tax matters. The amendment was that a chairperson of not less than 10 years experience in tax practice. In tax practice. So first of all, it is not any lawyer, but a lawyer of 10 years experience in tax practice. 2, the chairman shall be working with all the members.
Honorable member, hold on. Honorable members, having regards to the state of the business of the House, I direct that the House sits outside the regular sitting house. Please continue.
The chairman will be working together with members of the appeal board. No, so again, the chairman will designate. Here, we are not saying that the chairman will act alone. The chairman will designate. So his letter will say, this committee has been appointed. The person shall preside, shall be the chairman of the committee. That's all.
Mr. Speaker, Roman 8, Clause 4, amendment proposed under 4th Schedule, Paragraph 5, Subparagraph 4, delete and insert the following as captured on page 4.
In favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Item IX. Yes, Chairman, I called the amendment, item X.
No, IX, Roman 9. We are on Roman 9.
Yes, item IX, sorry.
Yeah.
Yes, Honorable Majority Leader.
My little worry is, I know this is it's going to be a very difficult enterprise with you presiding. The point that I want to make. I was just saying that this issue that I want to bring up, I know it's going to be a very difficult enterprise with you presiding.
In that case, I can recuse myself so that you let somebody else you trust preside.
Mr. Speaker, the matter that was brought up by the chairman of the Finance Committee relating to the chairperson, is it the case that in the absence of the chairperson, the board can never sit to agree on matters? Is that the case? Now, if that is not the case, why are we insisting that necessarily the chairperson must be a lawyer?
Yes, Honorable Member for West.
Mr. Speaker, the issue, we have to distinguish between the board as a board and panels of the board now going specifically into cases. What we are missing. The overall board chairman, person, should be a judicial person, a lawyer. But because they can form various panels to handle specific cases, that is where they can appoint anybody who is not a lawyer. That is what the issue here.
Mr. Speaker,
yes,
we come back to square one. The composition of the appeals board. The chairman raised issues and then wanted to effect an amendment. Much as I appreciate the principle espoused by members who prevail on him to withdraw the amendment, the question that I'm raising is, in the absence of the chairman, can the appeals board ever meet to adjudicate on matters referred to them? I believe yes. And if it is yes, why are we insisting that necessarily the chairperson must be a lawyer? Because if they have to adjudicate on matters, and I agree with the chairperson of the Finance Committee that in that regard, I think the better construct will be to have maybe as much as possible a lawyer to be the chair. Preferably a lawyer of some standing to be the chair. To insist that necessarily the chairperson must be a lawyer would then mean that in the absence of the chairperson, they can never sit to adjudicate on any matter. And I think that would be overstretching the issue.
Speaker, thank you very much.
Honorable Wawa, you have just spoken. Let me listen to Tamale.
In the composition of the appeals board, the original framers of the law anticipated that those on the appeals board. You seen it?
Sorry, what have you?
Yes, with non-verbal communication.
Yes.
The Speaker, the argument he's making, all the boards that we set up under various authorities, we normally will start by saying the person should be an experienced person in the field of several years practice or whatever. But once you constitute head board, anytime the chairman is not there, the members will elect among themselves a chairman to chair the meeting. It doesn't mean that it must be a lawyer who must always be there. But once you qualify and you constitute a board, and the board is to meet, the board can always, among themselves, select somebody to side. So it doesn't negate the argument that we are not making.
Yes, Honorable
Mr. Speaker, I agree to abandon the issue that I'm raising on account of a superior argument, not on the basis of what the Honorable Lecturer is saying. The reason really is contained in 3.1c, and not on account of the issue that he's raising, because there are two other lawyers. Any of them could chair. But to say that the chairman should be a lawyer and in his absence anybody else can chair would defeat the argument that we want to bring. Honorable Lecturer, with respect to you.
Honorable Minister, they have abandoned their wayward argument, so let's continue.
Chairman,
yeah.
Didn't get a sense of what my able leader was saying, because if okay, yes, please, because I want to get it, because if it's a panel system, okay, I defer to you.
Mr. Speaker, the proposal from the chairman was that the chairperson of the board should not necessarily be a lawyer. And I wanted to associate myself with him because in his absence, if the board has to sit and adjudicate on matters, then we don't have to say that the chairperson must necessarily be a lawyer. But I've seen that there are other members, indeed two other persons, who have the same qualification as the chairperson, contained in sub-paragraph C. So in his absence, and the insistence is on persons with the same qualification as the chairperson. So it's not possible to have all three being absent. So I'm saying that in that regard, if we have the lawyer as a chairperson, in his absence, he still will be covered by those other two persons. But the Honorable Chair's argument, I thought we should completely discard with respect to him.
Yes.
Right, Honorable Speaker, I thought when we talk about a panel duly constituted, it is defined. So it is said that the Court of Appeal shall be duly constituted by 3 judges. So that when you have the, with one presiding, so in the event that you do not have a presiding member of the Court of Appeal, you court. And the case will be adjourned by reason of the fact that we don't have a judge presiding. And that's how it goes for any serious engagement, unless there's an intention which is very serious. So my argument is very simple, that in the event that you don't have the chairman presiding, there's no quorum, and then the proceedings should be adjourned. Yes.
Okay. Now, I didn't have to prolong it, so
yes.
Please, let's proceed with item.
The quorum is defined.
Mr. Speaker,
wanted to seek your leave to bring the consideration of this bill to a close for today.
Minority bench, there's applied and consideration for now. Do you have any comment on that? Yes.
You see that the chairman want to go and do a reworking. So give it the time to go through.
That brings us to the end of consideration of the Revenue Administration Amendment Bill 2020 for today. Yes, Honorable.
Mr. Speaker, we want to continue item number 9.
Very well. Item Land Bill 2019 at the consideration stage. Clause 182.
Registration of stool, skin, clan and family lands.
Amendment proposed. Chairman. Yes, Honorable.
Mr. Speaker, respectfully, I believe we may have to suspend sitting for a brief while. The outcome of this morning's meeting, we are now printing the documents in the printing room, and I'll plead so that we have a very smooth sailing once we begin. If we can suspend for about 10 minutes. 10 minutes. Suspension. 10.
Later, it's 20 past 2. If you're going to suspend, then I suggest that we use that to a period to have lunch and come back at 3:30.
I agree. So we can come back at 3. We can come back at 3.
3:30. By the time you reach your office, eat, walk back. So
3 o'clock.
Very well. Other members, sitting is suspended. The House will resume at 3:30 on the dot. Yes, Honorable Majority Leader. Are you going to be able to continue without your minority side?
This week I believe we can, because the matters advertised on the order paper really represent the outcome of the winnowing endeavor this morning in my office. And we had colleagues from both sides of the divide with us in my office. The rest of them are engaged and give indication that we could proceed. Will join us later.
Very well. So, are we dealing with the other people addendum?
We'll deal with the other people addendum, the first item, that is item number 1.
Why? Very well. Consideration of the Land Bill 2019 suspended. Yes, leader, you may guide me.
Is there one on the other paper addendum?
Item number 1, the other paper addendum, presentation of papers by the chairman of the committee.
Reports of the Committee on Roads and Transport on the determination of the sea or otherwise of the Accident Investigation and Prevention Bureau Bill 2020.
The report is duly laid for distribution to members. Now, can we continue with the
Yes, Mr. Speaker, will revert to the consideration of the Land Bill.
Very well. The Land Bill 2019 consideration at the consideration stage. Clause 182.
Registration of stool, skin, clan and family lands.
Item I. Chairman.
Clause 182. Proposed. Sub-clause 2, line 1. Line 2. Delete land. So it will read, evidence by an instrument shall not be processed.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item II.
Clause 182, amendment proposed. Subclause 3, line 1. Delete intro and insert title. And then in line 3, at end, add and mapping division. So it will read a holder of an allodial title who intends to register that title shall demarcate and prepare a plan of that land with the approval of the Director of Survey and Mapping.
All in favor of the proposed amendment say aye. Yes, Honorable Leader.
Speaker, there's a bit of an amendment to the one proposed by the chairman. Instead of saying a holder of an allodial title, I think the better way to express it is an allodial title holder. An allodial title holder. Who intends?
Very well. All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item III.
Clause 1A2, sub 4, delete and insert the following. An alludial title holder shall not dispose of an interest in a portion of a land held by the alludial title holder, unless the whole land covered by the alludial title is registered.
As many as are in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item IV.
Clause 1 to add the following new subclause. For the avoidance of doubt, no plan of any parcel of land attached to an instrument shall be registered unless the land is demarcated and surveyed by an official surveyor, and the plan is approved by the director of the Survey and Mapping Division.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item V.
Clause 1A2. Add the following new subclause. Mr. Speaker, as advertised on page 2 of the order paper.
As many as are in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item VI.
Clause 1A2, subclause 5, line 1 and 2, delete registrar may, in consultation with the director of survey, and insert director of the land registration division may, in consultation with the director of the survey and mapping division.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item VII.
Clause 1A2, subclause 9, paragraph A, delete and insert the following. An occupant or a representative of the occupant of a stool or skin, or
as many as are in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item VIII.
Clause 1A2, subclause 9, paragraph B. Delete the paragraph.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item IX.
Clause 1A2, subclause 9. Closing phrase, paragraph C, line 1. Before is, insert who, and also delete under this act. And in line 4, delete holder and insert head. So the new rendition will be who is served with a notice may enter a caveat or apply for an order prohibiting or restricting a transaction in respect of a stool or skin, clan or family, land, on behalf of the stool or skin, clan or family, in the same manner and in the circumstances as the occupant, head, or member would be entitled to do under this act.
As many as are in favor of the proposed amendment, yes, Honorable Leader.
Mr. Speaker, just a bit of amendment to tidy up what we have done in the amendment proposed by the chairman of the committee in line 4. I think we have to add after the word occupant of a stool or skin. The same as the occupant of a stool or skin, or member of a clan or family. The Speaker, that makes it clearer. Even though that is what is intended, we just said as the occupant, head or member, and that doesn't make it clear enough. We say as the occupant of stool or skin, comma, head or member of a clan or family. I think that makes it clearer and proceed beyond doubt.
Yes, Honorable West.
Mr. Speaker, we quite didn't get this rendition completely resolved because we were talking about the family head accountability, and therefore what we wanted to be sure of is that is it a principal member of or just a member of the clan or family. So he is right when he says we should insert a member, but in that law, I think that either they use principal members, is the head of the family or clan, or the principal members. But we're not sure what is provided in that law, and we wanted that to be sorted out. I don't know whether it has been resolved and put like this. So if he's insisting on inserting a member, we can either put a member, but it should be according to the law that we passed.
Yes,
The Speaker, in this law before us, in this bill before us, we have never used principal to qualify a member. It never appeared anywhere in the bill. On the other hand, Speaker, if you take it from 8, Section 8C, it talks about, in fact, even the whole 8, it talks about the head or person, C, head of a clan or family, or a member of a clan or family. So when we come to the closing phrase, which in line 4 is talking about the occupant. The occupant means or refers to the of a stool or skin, as in 9A. And then the head or member also refers to head of a clan or family, or a member of a clan or family. And that's why I said we should just have to insert as the occupant, after occupant.
When they say a member, they say authorized by the family or clan. It's not just any member.
Yes.
If we remember in 9, is that a member authorized? So you have to show that you have the authority of the clan or family. It's the same as the principal.
Yes, that's exactly what I'm saying. He is saying that we should use the word principal. And
I agree with you. I'm pointing
used.
out to him that
Yes.
in areas where there's no authority, then principal members come in. But in this case, they are saying an authorized member. So you don't need, yes. As many as are in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now the question is clause 182 as we amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 182 as variously amended shall stand part of the bill. Clause 183.
Disposal of interest in stool, skin, clan and family lands.
Item X, Chairman.
Clause 183, line 2. Delete a grant and insert the grant. So the new rendition will be a change of a person authorized to make a grant of a stool, skin, clan, or family land shall not affect the of a stool, skin, or family.
All in favor of the proposed amendment say aye.
Aye.
All against say no. The ayes have it. The amendment is carried. Now, clause 183 as amended shall stand part of the bill. All in favor say aye.
Aye.
All against say no. The ayes have it. Clause 183 as amended is ordered to stand part of the bill. Clause 184. Yes, Chairman.
Clause 184, subclause 1, line 3, delete 100 and insert 97. So it will be section 97 may lodge a caveat, not 100.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 184 as amended is ordered to stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 184 as amended is ordered to stand part of the bill. Clause 185.
Notice and effects of caveat.
Chairman, amendment proposed.
Clause 185, subclause 1, line 1, after shall, insert with 7 days. So it will read within 7 days. So it will read, the landlord shall within 7 days give notice.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 185 as amended. Yes, Honorable Leader.
Mr. Speaker, I think we, in 1851, we added some words at the end. The land registrar shall within 7 days, where is it? Shall within 7 days upon the lodgement of a caveat. I think that is what you said. Shall, within 7 days upon lodgement of a caveat, give notice in writing of the caveat to a proprietor whose land or interest in land is affected. Mr. Speaker, that is the full complement of what he did.
Within 7 days from
Within 7 days upon the lodgement of a caveat, give notice in writing of the caveat to a proprietor whose land or interest in land is affected.
It is the upon launching that I want to propose that it should just be 7 days from the date or from the filing of the caveat. Yes.
Speaker, that is another sense, and I think that is okay. The value is the same indeed.
Yes. The land register within 7 days from the date of the caveat. Give notice. All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 185 as amended. 10 part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 185 as amended is ordered to stand part of the bill. Clause 186.
Withdrawal and removal of caveat.
Also advertise amendment to 186. In favor of 186 being a part of the bill, say aye. All against say no. The ayes have it. 186 is ordered to stand part of the bill. 187.
Caveat in respect of the same matter.
Clause 187 shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 187 is ordered to stand part of the bill. Clause 188.
Wrong caveat.
Item XIII.
Clause 188, amendment proposed, subclause 1, line 1, delete and insert or. So it will read a person who lodges or maintains a caveat wrongly wrongfully or without reasonable cause commits an offense.
Do we want that? Yes, Honorable Member for.
Thank you, Chairman. The reason is that if you look at the way it is, a person who lodges or maintains a caveat wrongfully and without reasonable cause commits an offense. That, if you say so, you are saying the two have to be together. But either things will be enough to commit the offense. That is why we are putting or rather than and.
Okay, without lawful cause, rather changes my mind. Okay.
Yes.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 188 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes of 188 as amended is ordered to stand part of the bill. Clause 189.
Notice of intention to register instruments affected by caveats.
Item XIV, Chairman.
Clause 189, subclause 1, line 2 and 3. Delete entry in the register, the registration or making of, and insert the following. An entry in the register, the registration or the making of an entry. So it will read, where an application is made for the registration of a disposition or the making of an entry in the register, the registration or the making of the entry, which is prohibited by a caveat.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 189 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 189 as amended shall stand part of the bill. Clause 190.
Lapsing of caveats.
Item XV.
Clause 190, subclause 1, paragraph B. Delete line 2, delete 190 and insert 189. So it will be given under section 189.
All in favor of the proposed amendment say aye. All say no. The ayes have it. The amendment is carried. Now, there as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 190 as amended to stand part of the bill. Clause 191.
Restriction.
Clause 191 shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 191 is ordered to stand part of the bill. Clause 192.
Notice and effects of restriction.
Amendment proposed. Chairman.
Clause 192, subclause 1, line 2, delete that and insert there. So the line 2 will read, entered in the land register to a proprietor affected by the restrictions.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 192 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 192 as amended is ordered to stand part of clause 193.
Removal and variation of restriction.
Clause 193 shall stand part of the bill. All in favor say aye. All against no. The ayes have it. Clause 193 is ordered to stand part of the bill. Clause 194.
Rectification of the land registrar.
Item XVII. Amendment proposed. Chairman.
Clause 194, subclause 5, line 1. Before land, insert there. So a person who is dissatisfied with the decision of the land registrar.
All in favor say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 194. Yes, Honorable Leader.
Mr. Speaker, a minor insertion. 1941C. 1941C. The Director of the Survey, of the Survey and Mapping Division. Insert the before survey.
I didn't understand you, Leader. On a survey verified and approved by the Director
There's no advertisement, but the Director is the Director of the Survey and Mapping Division.
Very well. All in proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 194 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. 94 as amended is ordered to stand part of the bill. Clause 195.
Rectification by court.
Clause 195 shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 195 is ordered to stand part of the bill. Clause 196.
To indemnity.
Item XVIII. Amendment proposed. Chairman.
Clause 196, subclause 3, redraft as follows. Where A, the loss or damage submitted application under Section 108, or B, an omission, a fraud, or any vitiating factor leading to the rectification was caused by the Lands Commission, the Lands Commission shall indemnify a person who suffers a loss as a result of the rectification.
All in favor of the proposed amendment say aye. Yes, Honorable Member for Wawes. So the question is, all in favor of the proposed amendment say aye. All against say no. The ayes have it and is carried. Now, Honorable Member for Wawes.
Mr. Speaker, the reference is to limitations. Limitations Act. It should be limitation, not no S.
Which?
That is the first subject to this act and the Limitation Act. The first separate one. Yes.
Very well. The draftsman take note and correct it appropriately. Yes, Honorable Majority Leader.
Mr. Speaker, I just want to the attention of colleagues to 1B. 1B, didn't we effect amendments on 1B? A mistake or an omission in the register which cannot be or not ordered to be rectified. I think we deleted this. Or do we allow, Mr. Speaker, if you can bring your mind to bear on B.
A mistake or omission in the register which cannot be or is not ordered rectified under this act.
Mr. Speaker, respectfully, if you take it from the preamble, we really were having some challenges. If you take it from the preamble, you would see the intent of it, and then perhaps we could assist in the appropriate formulation of B.
Subject to this act and the limitation 1972, NRCD 54, a person entitled to be indemnified by the Republic if that person has suffered damage in consequence of being deprived of or prevented from acquiring land on an interest or a right in the land by reason of B, a mistake or an omission in the register which cannot be or is not ordered to be rectified under this act. Yes,
Mr. Speaker, you see, if you delete S, the sentence will still be perfect. So if you also add this, then you'll be having two sentences within that same clause. That is why we
But,
deleted it.
well, why do we want to?
We delete is. It makes sense, or not ordered to be. Not because you see, if you look at it, it says a mistake or an omission in the register which cannot be or not ordered to be rectified under this act.
You see, let me try to see if I understand what is happening here. Right to be indemnified. And then say that if there's a mistake in the register, which cannot be rectified, or which is not ordered to be rectified, then that person who is affected by it will be entitled to be indemnified. So you should not remove it. It should be there.
The one moving the motion has given up, so we can carry on.
As an member for someone.
We argued so much that I was forced to read this provision. Allowed. Mr. Speaker, you are perfectly right. But if they are minded to move east, the east must go with north. But that is the position. We cannot be remedied, or we cannot be rectified, or is not by the court ordered to be rectified.
I think it should be there. So, clause 196
Mr.
as
Speaker,
amended. Yes, sorry.
upon reflection, because we really debated on this and we spent more than 30 minutes on this. But upon reflection, I realized that it should be there. Because you should really take it from the which. So a mistake or an omission in the register which cannot be rectified under this act, or which is not ordered to be rectified under this act. You have the fuller sense in that. But we debated and debated. As Mr. Speaker, I believe original should be left to stand.
All in favor of clause 196 as amended, be part of the bill, say aye. All against, say no. The ayes have it. Clause 196 as amended is ordered to stand part of the bill. Clause 197.
Amounts of indemnity.
Item XIX, Chairman.
Clause 197, paragraph A, line 2, after when, insert the loss or damage. So it will read, where the land register is not rectified, the value of the land, interest, or rights in the time when the loss or damage, omission, mistake, fraud, or other vitiating factor.
Yes, Honorable Majority.
Mr. Speaker, just a small readjustment. The insertion shouldn't come after the win. And in fact, if it comes after the win, then the word "they" in line 2, that is after win, should be deleted.
Yeah, so
Other than that, you leave the "dead" there, and then we insert loss or damage. Otherwise, we have two days. It will not be tidy.
Very well. So as many as are in favor of the proposed amendment, say aye. Or say no. The ayes have it. The amendment is carried. Now, clause 197. Yes, Leader.
Mr. Speaker, thank you very much. 197, just that you direct the drafters if it so sits with the chairman. When you read 197, the first two lines, these particular words, first line, an indemnity of the loss of land, and these are the words I'm particular about, an interest or right in land. Now, when you go further to 197A, it now reads value of the land interest or right. And then when you come to 197B, you have land interest or right. One of it must be correct and one of it must be used consistently. I don't know if I'm carrying the chairman and the colleagues along.
But Chairman, Leader, I think you're reading it without recognizing the value of the land.
Yes.
Interest or right in land immediately before the ratification. So there are two different things. Fine. All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now clause 197 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 197 as amended shall stand part of the bill. Clause 198.
Procedure for claiming indemnity.
Clause 198 shall stand part of the bill. All in favor say aye. All against say no. Ayes have it. Clause 198 is ordered to stand part of the bill. Clause 199.
Recovery of indemnity paid.
Clause 199 shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 199 is ordered to stand part of the bill. Clause 200.
Fees.
Yes, Leader, 199.
Mr. Speaker, sorry. The money is there. Monies. MON 199. Where monies?
Yes, that is correct.
YS.
That is correct.
Okay.
In legislation.
Not Swami Chitamani.
So, clause 200.
Fees.
There's no advertised amendment to clause 200. All in favor of clause 200 being a part of the bill? Aye. Yes, Honourable Member for Tamale North.
Right, Honourable Speaker, I just want to make a small proposal, and I hope that my colleagues will agree with me. Line 3. I want us to introduce clause 200, line 3. Prescribed and published. The fees, I want us to introduce and published under this act for transparency's sake, so that it will read, the Lands Commission shall charge in respect of any application, printed form, and any other matter connected with registration, the fees prescribed and published under this act, and the Lands Commission shall refuse to act until fees are paid. And published. The fees prescribed and published under this act.
The published is where? Published where? Or in the Gazette? Or the fees charged and gazetted? Because the Gazette is supposed to be knowledge. Yes, I remember for 1 hour.
Speaker, I think that discuss it a little bit, because his idea of the thing is that after you have approved or prescribed the fees, you must put it in a public place for people to see even before. So I think they added the published for the notice of the clients, people who are coming there.
Yes.
Mr. Speaker, even though I appreciate the principle, for reasons of transparency, and that people are not shortchanged, I appreciate the principle. But just to say that it should be published would not achieve anything. I think what you want is that the prescribed fees should be advertised at the appropriate place. Maybe it should be placed on a notice board so that people will not be subjected to the whims and caprices of individuals. But that really education. If you are saying that it should be well advertised at the public, that's different.
Frankly, the problem we want to solve.
Yes.
Wherever you place it, you won't solve it. The first thing is the people coming themselves want to sidestep rules, so they are willing to pay anything. When
I used to be at the village. We displayed the charges. They will come, stand, look at the charges, and then they'll ask them, lines is the same. And they'll tell them 5 times the figure. They come ready to pay, you know. But my introduction of published, if you're not careful, it becomes complicated. Does it become illegal because it's not published? That's the only problem I have.
Mr. Speaker, I think that it is encouraging that we all understand the principle. And so I will take guidance on how we can make amendments to this clause so that the principle is addressed, because it is displayed, displayed, advertised, you know, displayed. I think that I will go with displayed, so that even if people decide to ignore what is displayed and subject themselves to Guru boys like you suggested happened at the DVLA, it will not be as a result of the law not providing for the need for transparency. Yes, so we can say prescribed. So the proposal I have is prescribed and displayed at appropriate places, or at the appropriate place under this act. So maybe regulation can take it.
Yes, I was wondering if they cannot be taken care of under regulation, where to display it and how.
Yeah, Mr. Speaker, I think if we give the indication here, then regulation can take care of the place to display it. I think so. Thank you.
Very well. So all in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, yes, the same clause 200.
Yes. Speaker, with your leave and indulgence, on fees 200, the Lands Commission shall charge a fee. Why are we not qualifying it by putting the fees there? When you say the Lands Commission shall charge what? Even though when I read further, I'm guided by the reference to the fees prescribed under this act. But why are we not adding the words, the Lands Commission shall charge a fee in respect of any application form and any other matter? No, there's no fee there. Have you seen? Shall charge.
The fee is after the others.
I agree. In the second line.
Yeah.
But this is legislation.
Let me read it this way and see if
okay, thank
the
you.
The Lands Commission shall charge in respect of any application, printed form, and any other matter connected with registration, the fees prescribed under this act, and the Lands Commission shall refuse to act unless that is still have a problem.
Mr. Speaker, I still have a problem. Maybe you can put the question, but direct the draft person. I think that the charging of the fees must come in the first line. The Lands Commission shall charge the fees prescribed under this act. In respect of any application, printed form, and any other matter connected with registration. One part. And even the second part, I have a real difficulty. The words there, the Lands Commission shall refuse to act. Those words, we should put it rather positively. The Lands Commission shall only act when the fees are paid. When you say shall refuse to act, that is not, shall not act. There's something wrong there. That's why I say before the question, probably leader can look at it. But there's something fundamental. You cannot say shall not act is better. You cannot say shall refuse to act. I would agree with you. So if we can improve it, Mr. Speaker.
The Lands Commission shall not act unless, not until, unless the fees are paid.
What about the first part? Relocate the fees. Sorry? Okay. So all in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now clause 200 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 200 as amended is ordered to stand part of the bill. Clause 201.
Review and appeal.
Item XS, Chairman.
Clause 201, subclause 1, line 6, before commission, insert lands. Mr. Speaker, we cancel regional, so it will be lands.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item XXI. Chairman.
Mr. Speaker, is consequential. Subclause 2, line 2, before commission, insert lands.
All in favor of the proposed amendment say aye. All against say no. Yes, the ayes have it. The amendment is carried. Yes, Chairman.
Mr. Speaker, with your leave and indulgence, 201, line 1, where the land registrar, with your leave, we should delete the words and say is unable to perform any act. You don't say refuses to perform. It's more acceptable to say where the lands registrar is unable to perform any act or duty required of him. But if you say refuses, I don't find that 201. But the modern drafters are up, so let me rest for the time being.
Yes, Honorable Member.
Mr. Speaker, thank you very much. The issue is, if somebody is unable, has he offended? No. If he refuses, it's the one that makes it an offense.
Okay.
It's a review and appeal against a decision. All right. Okay. All in favor of clause 201 as amended shall stand. Clause 201 amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 201 as amended is ordered to stand part of the bill. Yes, Honorable Leader.
Mr. Speaker, I agreed with the minority leader when he introduced shall not act in 200. I agreed with him. But that was only momentarily. When we come to 201, the force of the refusal comes out. And I think that in that regard, we have deleted refuse in 200. That is why, upon reflection, I said that my agreement was only transitional.
The refuse then becomes a decision, which is appealable. Very well. So I will reverse. Which shall the persons are directed to revert to the original verse as in the bill. Clause 202.
Effects of review and appeal on registration.
Item XXII. Chairman.
Mr. Speaker, clause 202, read draft as advertised on pages 5 and 6 of the other paper addendum. Yes.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now clause 202 as amended, and part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 202 as amended is ordered to stand part of the bill. 203.
Lands Commission to state special case to the High Court.
Amendment for Chairman, XXXIII.
Clause 203, sub-clause 2, line 2, delete appeal, the final determination, and insert appeal the final determination in the case. So it will read a determination of High Court under subsection 1, or in the case of an appeal, the final determination in the case, conclusive and binding on the party.
Final determination of the case. Appeal against the final determination or decision. Yes, Honorable Majority Leader.
Mr. Speaker, the amendment proposed by the chairman is right, except that there should have been a comma after the appeal. You should not have deleted that comma. So that it will read, or in the case of an appeal, the final determination in the case is conclusive and binding on the parties.
Very well. So the appeal is not part of the determination. Very well. Yes, Honourable Member for Tamale Central.
We look at it as it appeared in the old law. There is no comma after appeal. The comma comes after determination. The comma comes after determination. A determination of the High Court under subsection 1, or in the case of an appeal, the final determination is conclusive. Is conclusive and binding on the parties. Oh, that is question.
Mr. Speaker, what he has read is what obtains in the bill, and that we found to be wrong. We should have added the final determination in the case. The final determination in the case. So it should read a determination of the High Court.
Even that of the case.
Of the case. The final, right, the final determination of the case. A determination of the High Court under subsection 1, or in the case of an appeal, the final determination of the case is conclusive and binding on the parties. That's how it should be.
Get it. I would have just said insert of the case after determination, and it would have been the same thing. Yes.
Mr. Speaker, I thank you for the opportunity. I believe we can save ourselves the hassle if we take the determination after the final and say the final decision is conclusive and binding on the parties. Yes, I agree. I wasn't there.
Mr. Speaker, the only reason why we can't use decision is that in the beginning, we have not used decision. We could as well have said a decision of the High Court, right? And then when we come to the second, we use decision. But determination of the High Court is the same as determination in the second. And Mr. Speaker, I'll plead with my colleague that we should rather join the window. He will not come. He plays the role of a reserve player, and when we come to plenary, he wants to delay the process.
This appeal must come with cost. It's all right, I don't remember. It's said in jest, unless you're making.
I'm defending my position in this matter. Mr. Speaker, I agree that in the opening sentence, we said determination of the High Court. And the use use of the determination is proper because that is a process of adjudication. But the outcome of the adjudication is the decision, is the final decision. So in my view, we are not using final determination because we use determination. No. When you determine a matter, the outcome is the final decision. My humble.
Yes, Honorable Member for
Thank you. The issue we discussed was that after the High Court order, if anybody appeals, he can either appeal to the Court of Appeal or to the Supreme Court. That is why we are saying if there is an appeal, the final determination of that appeal, of the case, is conclusive and binding on the parties. So that is the basis for this, the way it's drafted.
No.
Yes, Honorable Leader.
Mr. Speaker, I was agreeing to your advice to my colleague, but the Honorable Lecturer haven't held my appreciation of it. If the appeal is to the appeals court, constitutionally, are we to tell the person that he cannot proceed further to the Supreme Court?
That's what I said.
We cannot. So, convince me well.
No.
You said he may appeal to the appeals court or the Supreme Court, and the determination becomes final. If the determination is made by the appeals court, can this House be passing a law saying that a matter at appeal, not one of those restricted by the Constitution, like in respect of agency, where it may necessarily end at the Court of Appeal or elections, you cannot prevent or bar any person proceeding further to the Supreme Court. So, Mr. Speaker, initially I was minded to agree. Honorable Lecturer have further poisoned my mind that this amendment, we should take a careful look at it.
You see, the appeal did not state it to the Court of Appeal or to the Supreme Court. It is open-ended. So wherever it's determined, if after a Court of Appeal is determined and you don't want to proceed, that is the end. If you want to proceed to the Supreme Court and even for review until the final determination, I think it is open-ended, so we should let it go.
Mr. Speaker, just to be guided. So the Honorable Lecturer is not arguing as if the finality of the determination of the matter is at the appeals court. That being the case, I associate myself with it. I want it for the record.
Okay.
He's not arguing that.
Okay.
I think that you summarized it for the two of them. My friend behind was arguing with us, and we said no. The High Court is the one that you start in. But if you are not satisfied, you appeal to the Court of Appeal. After the Court of Appeal, if you are not satisfied, you appeal to the Supreme Court.
Okay, so
you can even argue. But the point is that once that final decision, the final decision is by the court where you are satisfied or you're not satisfied. But it means you have to get.
You have made your point.
So, all in favor of Clause 203 as amended, being a part of the bill, say aye. All against, say no. The ayes have it. Clause 203 as amended is ordered to stand part of the bill. Clause 2.
Publication of lists of registered interests.
Amendment proposed. Chairman.
Clause 204, subclause 2, line and 4, lines 3 and 4. Delete. Post the list on the website of the Lands Commission and insert. Publish the list in the Lands Commission Bulletin and on the website of the Lands Commission.
All in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Item XXV.
Clause 04, subclause 3, line 3. Delete by the and insert prescribed by the Lands by the lands. So it will read failure by the land registrar and the director of the land registration division to comply with sections 1 and 2 misconduct and is subject to the disciplinary sanctions prescribed by the Lands Commission.
All in favor of the proposed amendment say aye. All against say no. Yes, Honorable Leader.
Mr. Speaker, the chairman introduced the definite article before land in line 3. I think it's not captured here. So just that little insertion. So failure by the land registrar and of the land registration division. Comply with sections 1 and 2 constitutes misconduct and subject to disciplinary sanctions prescribed by the Lands Commission.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 204 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes of it. Clause 204 as amended is ordered to stand part of the bill. Clause 205.
General application form.
205 shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 205 is ordered to stand part of the bill. Clause 206.
Application of powers and functions of the land registrar.
Yes, Honorable Minority Leader.
I see the head note there. Application of powers and functions of the land registrar. But as I read the content, the powers and functions of the land registrar and the provisions of this act on title registration shall with the necessary modification apply to this registration. I'm sure 206 more speaks necessary modification to this registration rather than on just the powers and functions of the land registrar. And even if we want for emphasis, the content of 206 does not sit with the head note, in my view. So if the chairman can look at it, and chairman constitutional leader, when you say applies and functions of the land registrar, one would have expected that following through in 206, you have some powers being exercised. But you are talking necessary modification to apply to this registration. Mr. Speaker, the head notes will have to change. Maybe we are looking for powers and functions applied to this registration. Powers and functions of land registrar to apply to this registration. But I don't see, yes. So, leader, look at it. As it sits now, I'm not able to read the two together, the head note and then the content. So we should change the head note to reflect the content, Mr. Speaker.
We can, yes, leader.
Mr. Speaker, what is meant there really is modification of powers and functions of the land registrar to deed registration. That is what is meant there.
If you
can simplify it,
registration,
all the better. But it really is modification of powers and functions of the land registrar to deed registration.
all in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 206 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 206 as amended is ordered to stand part of the bill. Clause 207.
Registrable instruments.
Amendment proposed. Chairman, XXVI.
Clause 207, subclause 2, paragraph A, delete and insert the following. A, does not have subscription of the land to enable the land registrar to identify the location and boundaries of the land to which the instrument relates.
Honourable members, for the consideration of the House. All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item XXVII. Amendment proposed. Chairman.
Clause 207, subclause 2, add the following new paragraph. Does not have attached to the instrument concepts and statutory approvals required for the transaction evidenced in the instrument.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Yes. Honorable Minority Leader.
Mr. Speaker, with an indulgence, 207, if it's acceptable to the chair. The may there, should it be may or shall? If you have a conveyance vested 2071, the concluding line, a court judgment shall be registered under this act. Should it be may be registered? Why may? Because these are important things. A conveyance, vesting assent, certificate of purchase issued by a court, a power of attorney, caveat or restriction, a statutory declaration, and a court judgment may be registered under this act. My is why may and not shall. And if I have my way and the chairman won't object, it should be shall. Or it doesn't do any harm. May. Convince me why it should be may. A court judgment. If there's a court judgment, it shall be registered.
Tamale Central.
It should be made because the conveyance can be affected by matters that will not allow for registration. So there must be a permission to either refuse or register.
Yes. Got yourself.
South Day.
Sorry. South Day.
Yes. Mr. Speaker, I have looked at the area of instruments that are capable of registering under 207. And I think that we have left out two other registrable instruments in this category. And that will be wills as well as construction agreements. They have not been captured. But under 2071, registrable instruments, an instrument affecting land, including.
Will a vesting assent not take the place of a will? Because a vesting assent is the one which vests the property from a will. So, yes.
And then, Mr. Speaker, if we look at 1D, a certificate of purchase under the Borrowers and Lenders Act, that's not good construction. It should be a certificate of purchase issued under the Borrowers and Lenders, or issued pursuant to the Borrowers and Lenders Act, Act 208, Act that. But I suggest strongly that we should have a place for construction agreements, because these are special types of agreements, particularly in the BOT area of drafting instruments. That's build, operate, and transfer. Humbly submitted.
Constitutional legal.
The Chairman, sorry, Speaker, if we look at the beginning sentence of clause 207, an instrument affecting land, including. So, Mr. Speaker, it means the list is not exhaustive. If we were to list all instruments affecting land here, Mr. Speaker, we may not even find a space for it. That's one. And then number two, I agree with him that 201D, after purchase, we should insert issued, though it will still mean the same, but I think that it makes it clearer if we say a certificate of purchase. Obviously, a certificate is issued. So issued under the Borrowers and Lenders Act 2008 at 773. So, Mr. Speaker, thank you.
Yes, I think I'll put a question on the amendment entering issued. All in favor of the proposed amendment say aye. All against say no. The amendment is carried. Now the question is clause 207 as amended shall stand part of the bill. In favor say aye. All against say no. The ayes have it. Clause 207 as amended is ordered to stand part of the bill. Clause 208.
Plans attached to instruments.
Item XXVIII. Chairman.
Clause 208. Add the following new subclauses. Every plan shall be prepared by an official surveyor or a licensed surveyor. 4. The plan is prepared by an official surveyor. The plan shall be approved by the Director of Survey and Mapping Division. And B. A licensed surveyor, the plan shall be certified by the licensed surveyor and approved by the Director of the Survey and Mapping Division.
When it comes to survey, they know their area, so they keep it. When it comes to law, they want to introduce conveyances. Yes. All in favor of the proposed amendment, say aye. Against say no. The ayes have it. The amendment is carried. Now clause 208 as amended. Yes, leader.
Mr. Speaker, 208, just before you put the question, the head note, the plan there, I believe it should be minus the S. Plan attached to instrument, not plans. Plan of, yes. So the S. Yeah, I agree. But the head note say plans. Plans. I have a difficulty with the S. Because even when you come to the language 2081, the plan attached. So it shouldn't, the head note shouldn't read plans. It should be plan. Thank you. They modern drafters, they say singular means plural. We are learning from them. So thank you, sir.
Speaker. Speaker, thank you. There's a very serious one I need to draw the House attention to under 207. I know that we have
Let's finish 208. I'll give you a chance to go back.
Mr. Speaker, items related to how many are usually attached to the instrument. We, in some other clauses, indicated it should be triplicate. Yes, triplicates. And so it is not usually one plan that is attached to the instrument. So I'm thinking the S is in respect of how many are to be attached to the instrument. Thank you.
Yeah, man.
It will still have made sense if we had adopted the minority leaders' proposed amendment. Plan in the singular can also mean plans in the plural. But once it is the head note, we don't have to bring an indefinite article preceding the plan. So it can be plan, as Majority Leader rightly said, plan attached to instrument, and it can still mean plans.
All in favor of 208 as amended, being part of the bill, say aye. All against say no. The ayes have it. The amendment as clause 208 as amended is ordered to stand part of the bill. Now, I'll come back to 207, yes.
Mr. Speaker, thank you for the opportunity. Mr. Speaker, under 2071A, we stated a conveyance. And with all due respect, a conveyance is not an instrument. We mean a deed of conveyance. It should be a deed of conveyance. A deed of conveyance is the instrument. No, conveyance is the process of effecting the transfer. So what we mean is actually the deed of conveyance. Yes.
Yes.
Mr. Speaker, I believe the Honorable Nelson is still attached in Lodo's book on land law and conveyancing. And as we all read it, the two words went together, were joined together, deed of conveyancing. So I believe he has a case there. Thank you, Mr. Speaker.
Yes, Chairman.
Speaker, we don't even have to go far. A conveyance is defined at page 142. And it says this: conveyance includes a document in writing by which an interest in land is transferred. So it's not wholly correct that conveyance is justice. Conveyance also includes a document and is defined in the interpretation section. So there is no ambiguity about it.
If we define it here, it means we've made it a technical word. But otherwise, it's the deed which transfers, which is what we can register, the document. But because it is defined, it means that it becomes a term of art under the Act. Clause 209.
Proof of instruments.
Clause 209, subclause 2, line 3, and lines 3 and 5. Delete at the time of its execution and set the following in the language that the grantor has and the time of the execution of the instrument. And Mr. Speaker, with your leave, we insert the contents of that instrument. So I'll read the new rendition. The oath shall be on the instrument. The oath shall be on the instrument and state whether the grantor could read and write. And if the grantor could not read and write, state that the instrument was read over and interpreted to the grantor in a language that the grantor understands at the time of the execution of the instrument, and that the grantor appear to understand the contents of that instrument.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 2. Yes, Leader.
Mr. Speaker, I was just wondering whether after content we will not add something. Must he just understand the content or know the effects of it? No, that's why I'm asking for abundance of caution. He understands the contents in ordinary language.
Leader, this is a jurat. And the form and practice is very notorious. So I think this is sufficient, yes. Clause 209 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 209 as amended is ordered to stand part of the bill. Yes.
Mr. Speaker, we considered 10-2 and we didn't have any amendment, so if you can put the question.
Very well. Clause 210.
Heard before whom proof shall be made.
There's no advertised amendment to clause 210. All in favor of clause 210 being a part of the say aye. All against say no. The ayes have it. Clause 210 is ordered to stand part of the bill. That brings us to the end of consideration of the land bill for I think I can adjourn now. Can I, Leader?
Mr. Speaker, we want to break at this point and to still urge the gang in the winnowing committee to reassemble at 11th floor for us to continue with the winnowing process. There's nothing that the House can do without them. So I'm strongly urging them to retreat to 11th floor for us to continue the process. On that, Mr. Speaker, I believe we can bring
should I adjourn to
transaction
10?
of business.
Should I adjourn to 10 or to 12?
Mr. Speaker, because of what you're going to do this evening, I believe tomorrow morning will not meet. So we can adjourn to 10 o'clock. 10 o'clock.
Yes, Honorable Minority Leader.
Speaker, you can adjourn us to 11. Let's be realistic. This morning we all came, we're sitting here almost to 1 o'clock. So you want us to be objective. Whether you are meeting or you are not meeting, don't forget you have scheduled a meeting for our committee. Let's use 8:30 to 10 to clear it. So he should adjourn to 11 a.m. Yes, 11 a.m. 11 a.m., Mr. Speaker. Then the public is carried along. Other than that, when we come and we are sitting, no activity, it affects how they judge and see this institution. So I agree with you. 11 a.m., Mr. Speaker.
Yes, Honorable Leader.
Mr. Speaker, I think this morning's case really had to do with the fact that yesterday, because of the cabinet, the winnowing committee couldn't meet. So we had to meet this morning at 7:30 in order to transact business on before we came to meet here. So that explains why. So I was thinking that if we have to meet this evening, tomorrow we will not tarry as we did this morning. However, the minority reminds me of a program tomorrow morning, which is intended to commence at 8 o'clock. And we also have a committee meeting. So that being the case, it will mean that this committee meeting will have to go to about 10 o'clock. And that then will mean that realistically we will sit at 11. So 11 o'clock, the House will sit. Mr. Speaker, thank you.
Very well. The House is accordingly adjourned to Thursday, July 16th, 2020 at 11 o'clock in the forenoon.